version of the decision I've been given only has 3 pages, 4 pages. I don't need it now, but perhaps.
I think that would be more adequate. It's like if you have a mobile phone, the microphone.
Give her the password.
It's just that the audio levels will be different.
But it will be just his.
This.
Yeah, no, I'll put it on for you.
Okay. Oh, okay.
Good morning, everyone. Oh, sorry, you've just. Is that still okay? Good morning, everyone. My name is Jennifer Robinson. I'm an Australian lawyer, and I welcome you all here today on behalf of our legal team for Mr. Assange and WikiLeaks. I've represented Mr. Assange since the outset of this ordeal for more than 5.5 years. My colleagues today that will be joining me to speak, I'll be moderating and speaking. My colleague Melinda Taylor, who was counsel on this application to the UN Working Group and is an international and criminal lawyer based in The Hague. Can we fix the sound, please? Can you hear me now?
More.
Can you hear me now?
Yeah.
My colleague Melinda Taylor, who's co-counsel on the application to the UN Working Group on Arbitrary Detention, the decision that came down today, an international criminal lawyer. Christophe Marchand, a lawyer based in Brussels, who is an expert on criminal law and international law and has been advising us on the European Court of Human Rights. Baltasar Garzón, eminent Spanish jurist and the international coordinator of Mr. Assange's defence team. And of course, Julian Assange will be joining us from the embassy. This morning, our legal team will explain the UN findings, its implications, and what the UK, Sweden and the US must now do. We'll be hosting a Q&A after each of the speakers has been given an opportunity to speak briefly. And afterwards, interviews can be arranged and we'll explain how that will work at the end. The deprivation of liberty of Mr. Assange is arbitrary and in contravention of Articles 9 and 10 of the Universal Declaration of Human Rights and Articles 7, 9.1, 9.3, 9.4, 10 and 14 of the International Covenant on Civil and Political Rights. This was the finding of the UN in its decision handed down today, in a resounding victory for Mr. Assange. His situation and the circumstances of his detention were described by the UN as excessive and unnecessary. This independent decision comes more than 5 years after Julian Assange first lost his liberty on the 7th of December 2010, the day we walked together with him into a London police station. As the UN has found, he has been under various forms of continuous deprivation ever since as a result of the actions of Sweden and the UK. Julian is known around the world for his work as editor and publisher of WikiLeaks. For this work, he has received numerous awards from both journalism and peace organisations. Materials published by WikiLeaks have revealed war crimes, corruption and human rights abuse the world over, and now admissible in British courts and the European Court of Human Rights. This material has been used to assist victims of human rights abuse around the world, from Sri Lanka war crimes to US extraordinary rendition in the US, to document their cases and assert their rights. Amnesty International credits WikiLeaks with assisting democratic revolution, providing citizens the information they need to hold their governments to account. Just today, WikiLeaks released evidence of corruption and abuse by French mining companies in the Central African Republic. It is important to locate this decision in its broader context and to fully understand Julian's ordeal over the past 5 years. This may well be among the most widely reported cases in the world, but it's important to recall the facts. WikiLeaks commenced publishing material leaked from the US government in 2010. The collateral murder video showing the killings of Iraqi civilians and 2 Reuters journalists was published in April 2010. Chelsea Manning was arrested in May. In June, reports emerged of a Pentagon manhunt for Assange, and the Department of Defense confirmed a criminal investigation had commenced. In July 2012, WikiLeaks published the Afghan war logs, including detailed records of the deaths of more than 250,000 people. The Swedish preliminary investigation commenced in August 2010. After questioning Mr. Assange, the chief prosecutor in Stockholm dropped the investigation, saying the evidence disclosed, quote, disclosed no crime at all. It was reinstated sometime later. After remaining in Sweden for more than 5 weeks to answer this investigation, Julian was given the explicit permission to leave to London to continue his work. His lawyers have remained in constant contact with the Swedish prosecutor since, offering his testimony voluntarily. The prosecutor did not take up those offers. In October 2010, WikiLeaks released the Iraq war logs, documenting hundreds of thousands of civilian deaths in Iraq, and prompting the UN High Commissioner for Human Rights to state that the US had an obligation to investigate human rights violations revealed in WikiLeaks publications. In late November, WikiLeaks published Cablegate, 250,000 US diplomatic cables documenting war crimes, corruption, unlawful spying, and human rights abuse around the world. Just 2 days after this investigation and this publication, Sweden issued an arrest warrant to seek to interview Julian for the preliminary investigation. This was in the context of our repeated offers for Julian to answer questions in London under standard legal mechanisms specifically mandated by Swedish and international law. A week later, on 7 December 2010, the deprivation of Julian's liberty without charge began. Throughout the course of these publications in 2010 and subsequently, numerous high-profile statements have been made by US officials and politicians about the methods and tactics being used against Assange and WikiLeaks. This included unlawful FBI surveillance activity in Europe and placing pressure on allied states to bring criminal charges against Mr. Assange. At home in Australia, our Prime Minister accused Mr. Assange of unlawful conduct and considered cancelling his passport. Since then, Sweden's preliminary investigation stalled, with the prosecutor stating various reasons for refusing to interview Julian here in London to determine whether or not the investigation should proceed or be discontinued. She refused to do so despite it taking place in 44 other cases here in the UK since that time. We learned through FOI documents recently released, the UK advised Sweden not to allow Assange to give his testimony in London. On the other hand, the US case has progressed. This case has been ongoing for more than 6 years, confirmed again in December 2015, and the Australian government has described it as being of unprecedented in size and scale. While challenging his extradition, Julian was, according to the UN, held in harsh conditions for more than 555 days, including monitoring by electronic tag, reporting to the police daily. The UN was critical of the failure of judicial management of the circumstances of his bail here in the UK. In June 2012, Julian exercised his legal right to claim asylum and entered the Ecuadorian embassy in London due to the risk he faces of extradition to the United States. Ecuador has continued since that time to offer assistance to the Swedish prosecutor to resolve that matter. The decision today is incredibly important and a resounding victory for Mr. Assange. My colleague Melinda Taylor will now explain why.
Good afternoon, everyone. So finally, we have the verdict of the United Nations Working Group on Arbitrary Detention. And they issued a very detailed opinion which considers all arguments from Sweden and the United Kingdom. And this decision dispels the myth that Mr. Assange is either a fugitive from justice or that he could just walk out of the embassy. It is a damning indictment of the manner in which this case has been handled. It further affirms that Mr. Assange is a victim of a significant miscarriage of justice that is attributable to the action and inaction of both Sweden and the United Kingdom. It further emphasizes Julian's continued willingness to cooperate with the investigations in this case at all stages of the procedure. Now today I'm going to first address why we brought a complaint before the United Nations Working Group, and secondly, what are the findings of this working group. In terms of why we brought the complaint, there are two main reasons. First, he is and has been detained now for 5 years, 1 month, and 29 days. And to put it bluntly, that's a hell of a long time to detain someone who has never been charged and has never even been questioned by the Swedish authorities. He was detained in a prison, he was detained in house arrest, and he is detained in the Ecuadorian embassy. Now, the United Nations and international courts are very clear. Detention is not about bricks and mortar and bars. What matters is if you're severely deprived of your liberty. It doesn't matter whether you're in a jail in the desert in Libya or in the Ecuadorian embassy. If you have no effective freedom, if you are subjected to 24/7 covert and overt police confinement and surveillance, then you are detained and you are entitled to the rights and protection of detainees. Yet, Sweden and the United Kingdom just simply refuse to acknowledge that detention by any other name is still detention. But as Jennifer made clear, it's Mr. Assange's fear of the risk of refoulement to the United States which forms the prison bars which has now kept him detained indefinitely. There is a right to effective protection from persecution and torture. This is an inalienable right. But both Sweden and the United Kingdom refused to consider or provide any assurances that he would be protected in this regard. And as a result, it was completely illegal and disproportionate to expect Julian to renounce the only form of protection he had. Now, in terms of the findings of the United Nations Working Group, at the outset of their determination, they note with concern that Julian has been subjected to different forms of detention since 7th of December 2010. And this includes 10 days in prison, in isolation, which they criticize as being a particular harsh and illegal measure. And secondly, over 500 days of house arrest. And they note that even at this point, it already appeared to be unreasonable to maintain his detention. And then finally, over 3 years of detention in the Ecuadorian embassy. And on this point, the working group explicitly finds that the continued confinement and police surveillance of Julian in the embassy has to be considered to be a prolongation of these forms of arrest and detention. They then go on to find that there's 5 separate reasons why this detention is illegal and arbitrary. Firstly, every suspect has a right to be heard. They have a right to clear their name as soon as possible and assert their innocence. But Julian was denied this right for over 5 years, and was denied a right of access to the case file to defend himself. And we have to note here that for over 5 years, rather than questioning Julian in London or in the embassy, the Swedish prosecutor insisted that Julian had to renounce the only form of protection he had from persecution and torture. And this refusal of the prosecutor to consider alternative mechanisms was completely unreasonable and disproportionate. Secondly, the total length of detention, that's 5 years, 1 month, and 29 days, not 500 years, is completely contrary to the presumption of innocence. The fact that Sweden and the United Kingdom have completely denied that he's been detained for the last 3 years has also prevented him from obtaining any judicial remedy as to why it's disproportionate. Thirdly, the fact that he was faced with a prospect of an indefinite length of detention, because neither United Kingdom or Sweden were willing to resolve this impasse, in itself is illegal. And we have to note here that indefinite detention is actually a form of mental torture. Fourthly, the conditions of his detention fail to comply with the minimum standards for detainees. The embassy is not a proper facility for someone to live in for a long time, and it lacks appropriate medical conditions. And as a result, the United Kingdom's recalcitrance, their refusal to allow him to exit the embassy to obtain treatment, and this is the words of the working group, has put his health at serious risk. Finally, they found that the continued execution of the European arrest warrant is in fact illegal. The United Kingdom changed its law to recognise that non-judicial arrest warrants were abusive. If the same arrest warrant were to be presented to UK courts today, they wouldn't execute it. But for some reason, the United Kingdom refused to apply this new legislation to Julian's case. And as a result, he was denied the right to contest the continued reasonableness and proportionality of the arrest warrant in his case. Now, as Jen mentioned, they therefore found that this violated the protection against torture and cruel treatment, the prohibition against illegal and arbitrary detention, the right to a fair investigation and trial, and the right to dignity and humane treatment. They ordered Sweden and the United Kingdom to assess his situation and ensure his safety and physical integrity. And this is effectively a counterpunch to the United Kingdom's position that they simply don't recognise the Caracas Convention. That's irrelevant. Both the United Kingdom and Sweden are parties to the 1951 Convention. If Ecuador issues a founded decision that Mr. Assange faces a risk of refoulement, Sweden and the United Kingdom can't simply disregard that risk and fail to give it any weight whatsoever. They have a duty to ensure his right of freedom of movement in an expedient manner. We would interpret that to mean that he should be released and allowed to be free immediately. He should also be able to access his full exercise of his rights as concerns international norms of detention. The working group also found that it would be appropriate for the United Kingdom and Sweden to accord him an enforceable right of compensation. Now, obviously, you can't financially quantify the loss of family life, the lack of time he's had with his children, but this is an important symbolic recognition of the fact that he has been a victim of this process. And for years, Julian and WikiLeaks fought to expose abuses committed by governments and violations of rights of victims everywhere. And this has empowered victims throughout the world to obtain a remedy and fight for their rights. It is now completely unfair that Julian himself has become a victim due to his whistleblowing activities, and as a result has suffered uncharged, indefinite detention for over 5 years. Now finally, with today's decision, there is light at the end of the tunnel. We just need the United Kingdom and Sweden to step up to the plate so Julian can finally come out into the light. Thank you.
We'll now be hearing from Julian Assange inside the Ecuadorian embassy.
Can everyone hear me? Yes?
Yes.
Raise your hands if you can hear me clearly. Okay, great. Well, I've been detained now without charge in this country, the United Kingdom, for 5.5 years. That's 5.5 years where I've had great difficulty seeing my family and seeing my children. Today, that detention without charge has been found by the highest organization in the United Nations that has the jurisdiction for considering the rights of detained persons to be unlawful. I consider the outcome in this case to be vindication. The United Nations Working Group on Arbitrary Detention is the world expert body in understanding the law of when someone is to be detained or not detained. You've heard earlier from lawyers and from the UN itself about the status of the decisions of the Working Group on Arbitrary Detention. But let me repeat them here. The United Nations last night stated that the Working Group's decisions are legally binding. You'll hear more from Balthazar Garzon as to the level of its decisions. They are an opinion juris, which is higher in the hierarchy of international norms than domestic law, than treaties between countries. They are part of the founding basis of the United Nations, which the UK and Sweden are part of. Now, I have read this morning the comments of UK Foreign Minister Philip Hammond insulting the United Nations, calling a decision which I doubt very much that he's read ridiculous. I find those comments to be beneath the stature that a foreign minister should express in this situation. This is a serious finding. It adds to a already very important body of international law. And while I understand the momentary political imperatives for representatives of Sweden and the UK to look like they were correct in their earlier unlawful decisions, the fact is that they are not. There has been a final decision. There is no ability to appeal the decision of the United Nations. The lawfulness of my detention or otherwise is now a matter of settled law. The United Kingdom and Sweden had their opportunity to appeal. The last 2 weeks, they have had that opportunity. They did not lodge an appeal. They cannot now seek to object to the findings of a process which they themselves were involved in for 16 months. A jurisdiction which they submitted to, recognized, and in part founded together with their early involvement in the United Nations. You can't decide that you are going to recognize a forum, take place in proceedings, respond to the other party, and then at the end, when you don't like the outcome because you have been breaking the law and you don't even bother to appeal, come out with press statements and say, well, we disagree, or engage in purely superfluous ad hominem attacks, like saying that a finding is ridiculous. Those statements are simply for domestic consumption. They have no relevancy in terms of law. It is the end of the road for the legal arguments that have been presented to date by Sweden and the UK. Put simply, those arguments lost. There is no appeal. The time for appeal is over. No appeal was lodged. So I want to turn a little bit to where things go from here. It is now the task of the states of Sweden and the United Kingdom as a whole to implement the verdict. Now, why there can be attempts for the media, for the popular press, to look tough and attempt to undermine that, a serious attempt, not just for show, would have the effect of undermining the UN system. And there are consequences of doing that. And Sweden and the UK know full well that there are consequences. those consequences include not merely weakening a human rights and international law instrument to which both countries have signed binding treaties, but rather it will have the diplomatic effect, and diplomats know it. The diplomatic effect will be to make life difficult for Sweden and the United Kingdom to be treated seriously as international players that obey their international legal obligations. Their attempts, if they proceed to undermine the UN system, we'll see various enforcement measures that can be taken by the UN. Those initially, of course, can include the removal from UN committees, the movement against those states in various voting processes, and ultimately up to and including sanctions. Now, that's, of course, a matter for the UN to decide about how it's going to enforce its decisions, and a matter for Sweden and the UK to think, do they really want to go down that path? But we have now a victory and decided law on this case. It's a very interesting case. I suggest everyone go and read the result of the UN working group. WikiLeaks has tweeted it. You can also look on Justice for Assange, that's in the background here. And finally, I would like to thank the UN for considering over the last 16 months our submissions and those of the various states, and producing this verdict, which adds not just to my freedom and to justice for my children, but it adds, I think, significantly to the ability of the UN to deal with complex cases of arbitrary detention, including those involving Western states. Now, this victory came about not just because of the situation I am in, but because of a lot of hard work. And that hard work is from, first of all, Balthazar Garzon and John Jones QC, who had the initial strategic vision to bring this case. Melinda Taylor, who just presented, was the principal drafter. Stella Morris and Kerry Schenkman were secondary drafters, helping to pull all the other contributions together. Those other contributions came from Gareth Pearce of the UK, Michael Ratner, President Emeritus of the Centre for Constitutional Rights, Eric Borge from Oxford, Jennifer Robinson, who you heard at the beginning, and Candela Zussman, who is there in the audience. So with that, I would like to say thank you, that I miss my family, that we have today a really significant victory that has brought a smile to my face, and I hope many others as well. Thanks.
Thank you, Julian. I'd now like to pass over to the coordinator of our international legal defence, Balthazar Garzon. Please bear in mind we will be doing translation, simultaneous translation.
Buenos días. Buenos días. Brevemente, para dar posibilidad a las preguntas.
Good morning. Very briefly, to allow your questions.
En septiembre de 2014 se presentó la petición al Working Group y ha sido resuelta en diciembre de 2015.
We filed an application to the Working Group on Arbitrary Detention on September 2014, and that was decided on December 2015.
Para quienes no lo sepan, y parece ser que algunos representantes de gobiernos no lo saben, la existencia de los grupos de trabajo y el de detención arbitraria es una decisión de la Asamblea General y, por tanto, corresponde al sistema de Naciones Unidas y sus decisiones son imperativas y universales.
For those who don't know, and it seems that some government representative seems to ignore it, the working group mechanisms are created by the General Assembly of the United Nations, and as such, they belong to the UN system, and its hierarchy is imperative. The value of the level of their decisions is imperative.
El grupo de trabajo está en el Consejo de Derechos Humanos de Naciones Unidas.
The UN Working Group is under the UN Human Rights Council.
Anoten que Reino Unido es miembro del Consejo de Derechos Humanos de Naciones Unidas.
Please write down that the UK is a member of the UN Human Rights Council at the moment.
Solo por ese hecho está obligado a cumplir las resoluciones de uno de los grupos de trabajo de ese Consejo de Derechos Humanos.
That sole fact will bind them to comply with the decisions of a working group created under that group, under the UN Human Rights Council.
Se trata de un procedimiento de carácter universal.
It is a universal procedure.
Se trata de un procedimiento al que están sometidos los miembros o los países miembros de esa organización que se llama Naciones Unidas.
All UN state members are subject to such procedure.
Existe el deber de cooperar con los grupos de trabajo.
All state members have the duty to cooperate and to collaborate with the UN working groups.
Suecia y Reino Unido han aceptado esa colaboración y han tenido voz y opinión en este procedimiento.
Both Sweden and the UK had accepted that collaboration, and they had the opportunity to submit their arguments during this procedure.
Han tenido la oportunidad de argumentar sobre la petición que presentamos los abogados de Julian Assange.
They had the opportunity to respond to all the points of the application filled by the Assange lawyers.
Parece poco serio, por tanto, que ahora, cuando la decisión es adversa, digan que no tiene relevancia ese procedimiento.
Then, now it seems absurd that now that the decision is against them, and they have, while they have participated through the whole process, that now they are saying that this is not a valid decision.
Por aplicación de la Convención del Derecho de los Tratados de 1969, existe la obligación de cumplimentar las decisiones de este grupo.
By the application of the Vienna Convention on the Law of Treaties, they have the duty to respect this decision.
Como he dicho antes, tiene carácter imperativo porque nace de la propia Carta de San Francisco de 1945 y de la decisión de la Asamblea General de 2007 que crea el Consejo de Derechos Humanos.
It is imperative that they respect this decision because this mechanism is born out of the UN Charter and out of the 2007 decision to create the UN Human Rights Council.
Depende, por tanto, de la Asamblea General.
It depends from the UN General Assembly.
En 2011, el Consejo de Derechos Humanos, del que Reino Unido es miembro,
On 2011, the UN Human Rights Council, which, as we mentioned, UK is a member state,
ratificó la obligatoriedad de cumplir las decisiones de los grupos de trabajo.
confirmed that it is mandatory to comply with the decisions of the UN working groups.
En ese sentido, además, la decisión del Working Group tiene condición de opinio juris, es decir, opinión jurídica del máximo nivel para formar los estándares de derechos humanos a nivel universal.
The character of the decision by the working group is opinion juris. That means that it goes to the highest level and it shapes how a country will apply international human rights standards.
Así lo reconoce la Corte Internacional de Justicia,
It has been recognized that way by the International Court of Justice,
la Corte Interamericana de Derechos Humanos,
the Inter-American Court on Human Rights,
la Corte Africana de Derechos Humanos y de los Pueblos,
the African Court of Human Rights of the People,
el Tribunal Europeo de Derechos Humanos,
the European Court of Human Rights.
del que forman parte también Reino Unido y Suecia.
Both Sweden and the UK are members of the European Court of
El
Human
grupo actúa interpretando las normas de los tratados
So what the group does, they apply the law of treaties,
entre ellos el Pacto de Derechos Civiles y Políticos,
among them the ICCP,
la Declaración Universal
the Universal Declaration of Human Rights,
y el conjunto de principios que prohíben o que afectan a las personas sometidas a cualquier tipo de detención o prisión.
and all the principles applying to people subject to arbitrary detention.
Precisamente por ese análisis de todas estas normas,
After
sus opiniones, sus decisiones tienen carácter imperativo y de máximo nivel.
After applying all these principles, their decisions have an imperative character
La
at the highest
decisión,
level.
la decisión del Working Group de detenciones arbitrarias referida al caso de Julian Assange es de las más contundentes que he tenido ocasión de leer en toda la historia del grupo de trabajo.
It is the opinion that it is one of the strongest decisions that ever the working group has issued. After I have read most of the decisions, and during the 20 years of history, it's one of the strongest decisions that they have ever issued.
No es menor que se refiera a dos países de la Unión Europea, dos países, de Europa, dos países como Reino Unido y Suecia.
It is not a minor issue that they are studying the behavior of two European countries, of two members of the European Union, Sweden and the UK.
El grupo de trabajo dice que la decisión es arbitraria.
The working group
La
establishes
detención.
that the detention is arbitrary.
Que quebranta el principio de proporcionalidad,
It goes against the proportionality principle.
que es incompatible con la presunción de inocencia,
It is incompatible with the presumption of innocence.
que ha habido una pasividad absoluta por parte de la Fiscalía sueca,
That the Swedish prosecution authority has acted, has omitted to act.
que ha incumplido en forma sistemática cualquier posibilidad diferente a la que ha hecho, es decir, nada.
So she had breached all her obligations by doing nothing.
Pero anoten algo que es fundamental.
And please write this, that is fundamental in the decision.
El grupo dice, y cito en castellano pero textualmente, en el punto 97, apartado 6,
Yes. So I will read textually in the number 97 and 6.
se dice, se ha perdido el propósito y la eficacia de la justicia y el interés de las víctimas en cuestión de investigar este asunto al someter esta investigación a un estado de dilación indefinida.
So it defeats the purpose and efficiency of justice and the interest of the concerned victims to put this matter of investigation to a state of indefinite procrastination.
Todos los que somos juristas sabemos lo que eso significa.
All lawyers here know what it means.
Significa que ningún tribunal de ningún país democrático va a emitir una condena en el caso de Julian Assange.
What it means is that no tribunal from any democratic country, like described as such, will issue an indictment against Julian.
Por tanto, mantener la situación de privación de libertad con una detención arbitraria, como ha sido calificada, está fuera de toda aceptación jurídica.
Therefore, to keep him longer captive in an indefinite detention, which has been described as arbitrary, is completely unviable.
Pero fíjense que en el punto quinto de las áreas de trabajo prioritarias de Suecia, en la página de información sobre Suecia hecha por el mismo gobierno sueco,
You should know that one of the areas of priority, working priorities for human rights for Sweden, and it is established as such in even on the website by Sweden, while defining the human rights areas of work.
se dice que se encuentra el combate a las ejecuciones extrajudiciales y la detención arbitraria.
So the fifth priority for Sweden is to combat actively extrajudicial executions and arbitrary detention.
Y que continuarán actuando para evitar o eliminar este problema y elevarlo a la atención de las instancias internacionales.
So on that priority, they said that in the foreign policy priorities of Sweden in the area of human rights, they will keep combating arbitrary detention and elevating the issue internationally and elevating the issue to all the international fora.
Bien, pues las instancias internacionales ya han hablado.
Well, international authorities have had their word.
La máxima autoridad en el ámbito de detenciones arbitrarias y, por tanto, de protección del derecho humano a la libertad,
The highest authority in the matter of arbitrary detention and therefore in human rights in this specific area
ha establecido que esta detención es arbitraria.
has established that this detention is arbitrary.
Y eso significa que a partir de este momento
And that means that from this moment on,
no pueden ocultar esta decisión
they cannot hide this decision,
y cualquier prolongación de la detención arbitraria se convierte en tortura y malos tratos y, por tanto, de aplicación inmediata de la Convención contra la Tortura.
and any continuation of his detention from this point on becomes a time of torture and inhuman treatment, and therefore the Convention Against Torture now is applicable to the situation.
El grupo de trabajo dice que la situación de Julian Assange es peor que de haber estado en detención ordinaria y es peor que de haberse seguido el procedimiento contra él en esa situación.
The working group described the situation of Julian at the moment as worse than a situation of imprisonment, and even worse than if the whole procedure took place and he was found guilty.
Por tanto, la única decisión, y termino, que nosotros que procuramos respetar los derechos humanos y exigir ese cumplimiento que puede haber es la de la eliminación o supresión de la orden de detención europea emitida por las autoridades suecas, que ha quedado sin contenido y de forma insubsanable.
I end with this. The only viable solution here is to, for those who wish to comply with human rights, is to cancel the arrest warrant. The arrest warrant is at this moment empty in content and void by the decision of the working group.
Entre los preceptos que el working group dice quebrantados están los que se refieren a la tutela judicial efectiva,
Among the principles violated by this behavior and by this order is the due process,
el derecho a la libertad,
freedom,
la tortura,
torture,
el derecho a acceder a un procedimiento con las garantías mínimas de conocimiento del mismo,
right to a fair trial,
la igualdad
process,
ante la ley,
equality before the law.
es decir, casi todos los preceptos que se podían violentar se han quebrantado.
Basically, practically each and every right that could be violated was violated.
Y ello a pesar de que Julian Assange, desde el primer momento, como reconoce el grupo, ha estado dispuesto a cumplimentar los requerimientos de la autoridad judicial sueca.
And that was even considering the fact that from the first moment, Julian Assange was willing to cooperate in each and every moment with the Swedish prosecution authority.
Thank you, Mr. Garzon. We'll now hear from my colleague, Christophe Machan.
Thank you. I'm going to be very short, so I make only some comments because I was not in the team who drafted the demand to the United Nations, and because I'm more like, I would say, a criminal lawyer, and I work in different countries, in France, in Belgium, Netherlands, Spain, Morocco even, and my first question when I arrived in the case is, what is it about? And why are we saying today, why am I reading today in the papers that it is ridiculous what the United Nations would have said? And my answer to that, what is ridiculous is the arrest warrant. This Swedish arrest warrant is ridiculous for many reasons. The more we are digging in this case, the more we are finding reasons to find it very ridiculous. Remember, it has been said here that in the beginning, a prosecutor dropped the charges, and it's on the basis of these dropped charges that the warrant we are talking about today is still in force. And that's ridiculous. It's ridiculous to be here, so many people talking about this warrant that is 5 years old, about the situation a prosecutor in Sweden thought it didn't need prosecution. Then, when you think about the situation, and when you read the decision from the United Nations, something that is also very important is the situation in the UK. We all have to realize, and we all have to know that if today this same warrant would be issued by Sweden to the UK, it wouldn't be enforced, and Julian Assange wouldn't be in detention as he is for 5 years. That's what we are talking about, and that is what's ridiculous. It's not the decision that is very profound decision. There is a lot of argumentation, and that makes it so authoritative. This warrant, and the more we dig, the more we find things, as I tell you. We are now thinking that, and we have to realize that Mr. Assange is in jail or in detention, in de facto detention, says the decision, de facto detention because he cannot move out of the embassy without being arrested and under surveillance 24 hours a day. This detention is due to, in fact, all kinds of, we believe, as we are digging in this case, analyzing the situation and how the Swedish prosecutor has behaved, it's a negation of a due process. There is no due process for Mr. Assange in Sweden, and that's the conclusion of the group, as just was stated by Mr. Garzon, is that at the end of the day, today, the conclusion is that there is no possible trial of Mr. Assange in Sweden anymore. The fair trial has been infringed, and it's finished. It's not possible anymore to prosecute him there. Now, that is what ridiculous, that Mr. Assange has to stay in the embassy, in prison. But why is this situation? I cannot stop asking myself why. Of course, it's like this big question. It's the question of the elephant in the room. We all know that there is a US prosecution somewhere because Mr. Assange has been publishing information, because he's been editing information, that he's been denouncing gross abuses of human rights. That's the real question, and that is not ridiculous. That is not ridiculous, and that's the key of the question. Now, what will happen next? And Mr. Garzon just said it. It's to the UK and to Sweden to react, as we said already earlier. There are suggestions of remedies in the decisions, and of course there is this follow-up committee within the UN, within this Human Rights Council, that is going to check. It's a bit absurd, but the UK is going to have to check how it is implementing the decision. It is going to check how this decision is implemented. So we really believe that an end must come to this ridiculous situation, to this ridiculous arrest warrant, and that Julian Assange has to be freed. Thank you.
We'll now be taking questions. I'll take 3 questions at a time for the panelists.
taking on board everything that you've said, how is this anything more but a continuation of the stalemate? That we've already had the response from the UK and the Swedish governments, and they've said this changes nothing.
2 more questions and then we'll have...
2 questions, really. First of all, are we going to get a chance to talk to the principal speaker here, Mr. Assange himself, and ask him questions? And if we're not, I will ask the question to you, but can you answer that question first of all?
he won't be joining the Q&A.
First of all, can we ask them why it is not possible to put the questions directly to Mr. Assange? Can we ask whether or not it was a genuine offer to walk out of the embassy and submit himself to arrest, if he already knew at that point that he'd won his case in any case? And in which case, why not make that offer a month ago, or when the case was first submitted to this United Nations group? But you also seem to be losing the support of even some of your friends. The Guardian this morning saying that it's a publicity stunt, that WikiLeaks was founded on exposing those who ignored the rule of law. Surely its editor-in-chief should recognise its duty to see it upheld.
I ask that people keep their questions to questions rather than statements, but thank you.
It's a question I'm asking.
Yes.
Caroline Green, what specifically will it now take to get Julian Assange out of there, and does he have anything to say today to the Swedish women who, of course, were where this all began?
Sure. I'll address the second question quickly. Julian will not be addressing the session this afternoon. Given that this is a legal decision, we've taken the decision that the legal team will be answering questions on the UN decision today. Melinda, would you like to take the first and third?
Thank you very much. Regarding the first question, thank you, Lisa. Well, as Mr. Gasson mentioned, there are various remedies, but most importantly, there's the issue of what moral authority will the United Kingdom and Sweden have as democratic states, as key members of the United Nations, to criticise other states for locking up activists, for shaking their fingers at states which they deem don't comply with international law. Now, the United Kingdom is a member of the Security Council. Does it really want to set a precedent of states just completely disregarding the United Nations, which it itself participates in? And this system of international law, apart from the courts which apply it, it's also based on mutual recognition. Tomorrow, all around the world, there could be United Kingdom or Swedish nationals locked up somewhere. They will turn to the working group for a remedy. And I'm sure that when that occurs, the United Kingdom would hope that the states that have locked these people up will enforce the decisions. So rights are universal. They apply not just in rogue nations, they apply in the United Kingdom and Sweden. And unless the United Kingdom and Sweden want to join those rogue nations, they really do have to comply. Now, regarding the third question, what will it take to get Mr. Assange out of the embassy? What the decision stresses is his right to effective freedom of movement, but also that his liberties must be compatible with his fundamental rights. And it's quite notable that they mention his right to safety and protection. As a practical matter, for his right of movement to be effective, he would need his passport to be returned. The second aspect, and the working group was very critical of the very superficial way the United Kingdom and Sweden treated his right to asylum, that is an issue that must be addressed. He was granted asylum under the terms of the 1951 Refugee Convention. The United Kingdom and Sweden are parties to this convention, and they are obliged to give due weight and appreciation to Ecuador's valid and well-founded determination. Now, as to the question as to what Julian would say to the women involved, now the process requires that Julian be questioned so his voice can be heard. And that's the very crux of the complaint in the decision, that for 5 years the Swedish prosecutor was obliged to speak to Julian, to hear what he had to say. He offered himself up for questioning in Sweden, in London, and in the embassy. He said, come to the embassy and interview me, or I'll do it by video link. And this is something which occurs in numerous cases in Sweden, but out of hand, the prosecutor refused to do it. And that's what made the investigation grind to a halt. It wasn't Julian, it was a prosecutor. And that's what's very clear from today's decision.
A quick follow-up. Things have changed since that complaint was submitted and the Swedish prosecutor offered to come to London. She has now agreed, I understand, that Ecuadorian officials can put her questions to Julian Assange.
La cuestión es que la fiscal se ofreció a venir y no cumplió ninguno de los requisitos a los que estaba obligada.
The situation now that we have is that she offered to come, but she didn't comply with all the requirements for that to take place.
El acuerdo entre Suecia y Ecuador establece que se deben de cumplir los requisitos legales de la legislación ecuatoriana.
According to the treaty signed between Ecuador and Sweden, they established a series of legal requirements according to Ecuadorian law that they have to comply with if they want to come and do it.
La cuestión ahora es que hay un organismo, el organismo competente de Naciones Unidas, que dice que hay una situación ilegal, es decir, una detención arbitraria. Por tanto, seguir hablando de lo que dice la fiscal es que sería incidir en la misma ilegalidad que está denunciando Naciones Unidas. Lo que tienen que hacer es poner inmediatamente en libertad a Julian Assange y después se podrá seguir hablando.
The situation that we have now is a decision from the UN stating that the situation that Julian is at is illegal. He's arbitrarily detained. So continuing discussing whether the prosecutor can come, that shouldn't be the object of our discussion anymore. What we should be discussing here is the situation of the illegality that he's in, that he must be released immediately, and after he's released immediately and out of there, we can continue the discussion on the prosecution authority.
Quien está detenido arbitrariamente está en situación de indefensión absoluta y no puede ningún organismo judicial amparar esa situación ni un minuto.
A person who is arbitrarily detained is in a position of he cannot defend himself legally. It is in a vulnerable situation, and no court, no judicial mechanism can convalidate that situation by performing an act.
I'd also just like to give Christoph the opportunity to comment.
Yeah, I just wanted to add, if you have finished. Yeah? Are you finished? Yeah. About this situation, of course, this case is very, very complex in the sense that there are so many states involved. Sweden, Ecuador, the UK, Australia, the US. So it makes it very difficult to know how it's going to happen when you look at the international criminal side of it. And what is very important, the question of questioning Julian Assange in the embassy, is that the prosecutor, the Swedish prosecutor, refused until May 2015, which is, and we know that the facts were in 2010, so it's 4 or more years that he refused to do this usual multilateral cooperation with the UK, and it's only because the Supreme Court said or made understand to the prosecutor, the Swedish Supreme Court in May 2015, that the prosecutor began to think, okay, I'm going to do it. But you don't do an interrogation in an embassy like an interrogation in a police station like everywhere. And what did the prosecutor? She sent an email to the ambassador. It's totally crazy. It's totally against every rule of international law. I mean, if you want to do some cooperation, you have to send information to the Foreign Office. That's really the sovereignty between states. But that was not the way it was acted. So a lot of time was lost because she behaved, I would say, not very fairly. And afterwards, after analyzing the situation, the conclusion was that a new convention, a new treaty had to be signed between the two states, Ecuador and Sweden. And that's not something easy. That's something that took time and that also needs some procedural requirements. So that's why it took so much time.
3 more questions. We have one up the back there. One at the back. Where are the microphones, please? One here in the front, and the fellow in the red scarf. If you can pass it back.
To make it very clear, why Julian doesn't just walk out from the embassy, and is he afraid to end up in the USA jail?
The next question was here in the front.
Hi, Pia Gripenberg, Swedish newspaper. Did I understand it right that Julian Assange will not answer any question as long as he is still in the embassy? Or if I didn't understand it right, is he prepared to answer the question from the prosecutor?
And the third was the fellow with the glasses at the back.
Rob Brumby, ARD Television Germany. If it is the moral victory you suggest it is, why doesn't he dare the authorities to arrest him by walking out the front door?
Melinda.
Okay. Actually, all three questions are interrelated, so I can address them relatively simply. Yes, Mr. Assange is not walking out because of the risk to the United States, and that's a risk which hasn't been addressed by Sweden and the United Kingdom. This case has always been about the fact that there's an ongoing investigation into Mr. Assange, into WikiLeaks of an unprecedented scale. It's about the fact that in 2012, when he walked into the embassy, the Special Rapporteur on Torture issued a finding that Chelsea Manning had been subjected to cruel and inhumane treatment, and that this had occurred while he was being interrogated into Mr. Assange. Now, of course, no one should have to expose themselves to that risk. Why should Mr. Assange have to face torture, cruel, inhumane treatment? That's just not a question we should be putting to anyone in the world. Now, in question of why will Mr. Assange not answer questions, this is not why we're here today. The question is, why is an arbitrary detention continuing? The working group has found that there was a violation of arbitrary detention. He is subjected to cruel and inhumane treatment by being subjected to indefinite detention. Every day in detention is a crime. He should not have to be in detention any longer. You can't keep him there for the purpose of questioning. 5 years they had a time to question him. They didn't use it. He needs to be released, and that's what the focus really is on. You can't maintain this situation any longer. Again, in relation to the third issue, I think I've answered it as to why he doesn't walk out just like that, because there are issues which need to be addressed to secure his fundamental rights.
La decisión del grupo establece que se le han privado sistemáticamente de los derechos que cualquier persona tendría en un proceso penal.
The decision of the working group establishes that his rights has been rights of any person subject to a legal process has been systematically violated at all stages.
No solo la libertad, sino el derecho a acceso al procedimiento.
Not only his freedom, but his right to access to the procedure.
El derecho a presentar pruebas de contradicción.
The access to submit evidence of his innocence.
El derecho a conocer las imputaciones.
Even the access to the files and the documents of the proceeding, knowing what he's been accused of.
Durante 5 años, la fiscal no ha tenido necesidad de interrogar.
During 5 years, the prosecutor didn't have any need to interrogate him.
Ha podido hacerlo durante esos 5 años.
Because she could do it during these 5 years.
Y parece que ahora quiere hacerlo cuando se reconoce que está en situación de una violación sistemática de sus derechos fundamentales, Julian Assange.
Now it seems that she wants to do it now that it is recognized that he is subject to a systematic violation of his human rights.
Julian Assange siempre ha dicho que está dispuesto a declarar.
Julian Assange has always stated that he's willing to answer the interrogation.
Pero incluso la voluntad de declarar confronta con situaciones indisponibles de derechos humanos.
But even the willingness to answer is incompatible with human rights violations.
Practicar diligencias desde que en diciembre el Working Group ha notificado o ha resuelto y notificado ahora que hay una detención arbitraria, exige la cesación de esa detención arbitraria. Y a partir de ahí no hay ningún problema en que continúe el procedimiento, pero la situación de detención, la orden de detención europea tiene que cesar inmediatamente.
No judicial act can take place while a situation of arbitrary detention is being declared and taking place. The situation of arbitrary detention has to stop, so any interrogation or any other judicial act can take place. The situation of arbitrary detention had to stop immediately.
No es una victoria moral,
It is not a moral victory.
es una victoria jurídica en toda su extensión.
It is a legal victory to its
No
fullest
estamos,
extent.
no estamos hablando de sentimientos ni de opiniones.
We are not talking about feelings, sentiments, or opinions.
Estamos hablando del sistema internacional y universal de derechos humanos. O lo creemos o no lo creemos.
We are discussing here the validity of the universal human rights system. We either believe in respect it or not respect it.
Además, no es una cuestión ya de gobiernos, que podrán tomar la decisión que quieren. Es que judicialmente es insostenible esta situación.
It is no longer a matter between states whether they can opt in. It is a situation that has been declared and judicially has to be fixed immediately.
Si hablamos de política, hablamos de la doble moral y cómo Suecia quiere ser parte del Consejo de Seguridad y sin embargo no cumple ahora una decisión del Consejo de Derechos Humanos.
If we discuss double moral issues, we should consider that Sweden, for instance, wants to be a member state of the UN Security Council, and at the same time, it is performing these violations, human rights violations of the system.
Si estamos pidiendo que se cumplan las decisiones a otros países, deberíamos de cumplir las que nos afectan.
If states demand that resolutions concerning other countries are respected, then they should comply with the decisions, even if adversarial to their position.
Llama la atención que Reino Unido hable de decisión ridícula.
It is very interesting that UK is describing the decision as ridiculous.
Y que, por ejemplo, pues en relación al periodista Jason Razian, Irán haya cumplido lo que dispuso el grupo de trabajo.
And regarding the journalist Jason Razian, they comply with they encourage in the case of the journalist Jason Razian, Iran comply and respected the decision of the working group.
Indonesia ha cumplido el caso de Philip Karma también.
Or Indonesia, which comply with the decision on the case of Philip Karma.
Y otros casos que son cumplidos por países que teóricamente no tienen el estándar de derechos humanos como Suecia o Reino Unido pretenden.
And there are a series of cases and states complying with the decisions of the working group of countries that do not have the level and the human rights standards of Sweden or the UK.
Y en cuanto a salir de la embajada, saldrá inmediatamente que la orden de detención se anule.
And,
es decir, cuando le sea concedida la libertad.
And regarding the arbitrary detention, regarding his exit to the embassy, to answer that question, he will be out of the embassy immediately when the European arrest warrant is cancelled and he can exercise his right of freedom of movement.
En cuanto al asilo, el grupo de trabajo claramente dice que sin entrar a analizar si los estados lo reconocen o no, está justificada la actitud y la posición de Julian Assange ante el temor cierto que supondría una entrega a los Estados Unidos.
Even if if the decision does not study in deep the asylum question, they say that
y se deberían de haber tenido en cuenta, léelo en inglés, 97.5.
So I will read it. Irrespective of whether the grant of the asylum by the Republic of Ecuador to Mr. Assange should be acknowledged by the concerned states, and whether the concerned states could have endorsed the decision, and wish of the Republic of Ecuador, as they had previously done on the humanitarian grounds, the grant itself and the fear of persecution on the part of Mr. Assange, based on the possibility of extradition, should have been given fuller consideration in the determination and the exercise of criminal administration, instead of being subjected into a sweeping judgment as defining either merely, hypothetically, or irrelevant?
Unfortunately, I'd hoped that we'd be able to take another round of questions, but I'm being told we need to wrap up. After this, we'll be having all of the panelists will be available for interviews in Spanish, French, and English. We also have Jeffrey Robertson QC, who I understand is here at the Frontline Club, who is able to give comment. In short and in conclusion, you cannot uphold the law by breaking the law. And this decision today has found that Julian is arbitrarily detained, which is an unlawful status, and we hope and expect that the UK and Sweden will respect this decision. I'd like to invite Joseph Farrell to come up to explain how the interviews will work after this conference.
For anyone who wants to interview Jen or Melinda, if you come and find me, they'll be doing the interviews in the room downstairs. For Christoph and Balthazar, they'll be staying here. And can you find Dan for Balthazar? Dan, he's at the back there. Go to him to get your name in a list. And Joe for Chris.